So again, good afternoon and welcome. My name is Brandy O'Bannon. I'm the Executive Director from the Lebanon Community Hospital Foundation. And we're so excited that we have lots of attendees for today's great MedTalk, which is going to talk about kind of basic estate planning and why we all need a will. So we'll get started in just a few minutes with our presenter, but just a few housekeeping things today you can all help us with. You're doing a great job, but if you could please keep yourself on mute since we are expecting a large crowd this afternoon. When the presenter joins us and begins their PowerPoint, you can actually, if you'd like to turn your video off, that kind of helps with minimizing distractions. And then Jessie Meyer is our presenter, and I'll introduce her in just a minute, but we will try to hold our questions until the end of her presentation, but please be thinking of what questions you might like to ask her. She's allowed for about 20 minutes at the end of today's talk. You can type those questions into the chat. I'll help monitor those. Also, at the end of the presentation, when we call for questions, feel free to turn your camera on and unmute. You can use the raise hand feature up there at the top ribbon, and we can help you with that at the end of the talk. So again, welcome, and we're excited to see so many faces. It looks like over 100 people have joined us this afternoon, which is exciting. So I think I'll go ahead and share the background of today's speaker. So Jessica Meyer was raised in Park City, Utah in 2005. She graduated with a doctorate in jurisprudence from Willamette University, the School of Law, and she oh, there's Jessie, and she became a member of the Oregon State Bar. Jessica began working at Morley Thomas Law in February 2006 and became a partner at the firm in January 2011. Her main practice centers on estate planning, probate, trust administration, and guardianships, conservatorships. Jessica has been a full-time justice of the peace in our community here in Lebanon since January 2019. And Jessica's very proud to announce she is a trustee at our Lebanon Community Hospital Foundation. She's been married to her husband, Jared, for 18 years, and they're a happy family with 4 children. So welcome, Jessica Meyer. And at this time, Jessie, I'm just trying to turn it over to you if you want to share your presentation and anything else you want to share about welcomes or procedure before we get started. And again, welcome, everyone.
All right, thank you. I appreciate everyone in attendance today. I'm excited for the opportunity to talk about estate planning and specifically about why everyone needs a will. And just to make sure, I just want to make sure everyone can hear me. So I guess wave if you can hear me. Good, okay, I see people waving. So I am going to share my screen here. I have a PowerPoint presentation that I would like to play. So hopefully this will work for me as well too. So the title of my presentation is right here, Why You Need a Will. There are definitely different types of estate planning tools, wills and trusts being the main two, but today I'm going to focus on wills because we have a limited amount of time, and I would say that at least everyone needs a will. So we'll talk about that today. And my legal assistant's great. She's stuck in some memes for me here. So what is the importance of a proper estate plan? Lots of different things. First, they save a lot of time. If you have all of your assets lined up and individuals lined up to take care of them for you and directions on where those assets need to go after your death, a lot of time can be saved with a proper estate plan. And because time is saved and fighting is eliminated for the most part, a lot of money can be saved if your estate plan is put together properly. Also, family relations. You would be surprised. In my years, so I've been practicing in estate planning and probate for 15 years now, and you would be surprised what I've seen families fight about. In fact, I can remember one, and it was many years ago, a family who was fighting over this mechanical, well, it was a wood splitter is what it was, and they just fought tooth and nail about this wood splitter, and I've seen that over and over again. So saving family relations is a great great pro of having a proper estate plan. If you can spell out where you want assets to be distributed and who's in charge of distributing them, that eliminates a lot of infighting within your family and friends. Proper estate plan absolutely can save you taxes. Oregon has an estate tax, and your estate will be taxed on the amount over $1 million over at your death. So if you have a larger estate, it is extremely important for you to have a proper estate plan so that you can plan to eliminate or reduce the estate tax in Oregon, and income taxes too. Did you know, and I'm gonna slide this in for the Lebanon or just Samaritan Hospital Foundations, that if you have tax deferred accounts and you have an intent to leave something to a charitable organization like the Samaritan Hospital Foundations, you can give them some of your tax deferred accounts so that when those accounts pay out at your death, those charitable organizations do not have to pay taxes on them. So lots of different tools you can use to save taxes. And I think the big thing is, at least for me as an individual, is a proper estate plan allows you to make decisions of who, where, when, and how your assets are transferred at your death. And having that control is extremely important. It's important to me, and it's important to the clients I serve too. All right, so I use this example sometimes about how everyone needs an estate plan, whether you're young or old, whether you have children or you do not have children, whether you're married or not. Even if the only things you own are a motorcycle and a checking account, everybody needs a plan governing where those assets will go if you die. So whatever that plan is, it needs to be put in place prior to your death. All right. So I want to go over a little bit because many of you might be curious about this. Is what happens if you do not have an estate plan or a will? If you don't have an estate plan, the state of Oregon have rules of intestacy, is what they're called. And those rules govern where your assets go when you die if you do not have an estate plan. So a lot of those intestacy rules give assets to the people, the exact people that you want to leave out of your estate. So I've had examples over and over in the years when I've practiced in probate law, which I currently do, where someone has not had a will, and because of that, their assets go to relatives that are in jail, relatives who they didn't like, people in their family who are disabled, and then they get disqualified from their benefits. There are lots of reasons why you do not want the rules of intestacy to govern your assets on your death. I did have one example recently where I handled an estate of an individual who had millions of dollars in real property, in investment accounts, and he was really close with some of his family and not close with others. But he died and did not have a will. And so instead of him being able to decide where all of his assets went, I had to divide them up in his estate plan or in his probate to those people that the state of Oregon decided for him would receive his estate. And that is under the rules of intestacy. So let's kind of look at what that looks like. First, if you do not have a will and you are married and you pass away, any assets you own, and we'll go over some exceptions to this later, but any assets that you own would go to your surviving spouse. That's only the case if your spouse is also the parent of all of your children. Because if your spouse is not the parent of all of your children, then the rules of intestacy are going to split your estate 50% to your surviving spouse and 50% to your children from prior relationships. So that becomes a big problem sometimes for people that are currently married and they would like their spouse to receive their assets, but instead their children from prior relationships end up getting 50%. So if you pass away, you do not have a will or an estate plan, and you are not married, then the next layer of individuals who would receive your estate would be your children. And if not children, then your grandchildren, and on to great-grandchildren, as you can see. But if you die and you do not have a spouse or any children or grandchildren, then we pop back up and your estate would go to your parents. And if your parents are not living, then down to your siblings. And you can see how this chart flows, right? And then down to your nieces and nephews and great-nieces and nephews. And then again, if there aren't any siblings and no immediate family, then we're going all the way back up to your grandparents. And then down from there, aunts and uncles and cousins. And that's when we have estates where we're giving assets to your second cousin twice removed when we get all the way down to that third column there. So as you can see, this chart shows where the rules of intestacy would give your estate, and a lot of times that is not where an individual wants their assets to be distributed. So that is why it's so important that prior to anyone's death that they prepare a proper estate plan, and I'm going to talk about wills specifically. Another thing to think about is distribution by representation. So this comes into play not only in a will, but also in those rules of intestacy. So here's this chart I found where there's an individual, Amy, who has passed away. And Amy had 3 kids, and her daughter, Bridget, has passed away. So her estate would go 1/3 to Charles, her child, 1/3 to David, and then the rules of intestacy would then give her daughter's 1/3 down to her kids. So when we're talking about layers of individuals, I have a lot of clients who believe that their grandchildren and great-grandchildren are not ready at all to receive any part of their estate. And in this scenario, without a proper estate plan, those grandchildren are going to receive their mother's 1/6, or their mother's 1/3 divided in half. So another thing to think about, without proper planning, this is how your assets would be distributed if a child had died. All right. So I want to talk about some functions of a will and some specific aspects of how a will works. So first, your will govern any asset you own upon your death. So if I die and I have a bank account, my will is going to govern that bank account. There are some exceptions to that rule, though, and the first one is a joint asset. So if you, for example, co-own a bank account with anyone, your spouse, a friend, a child, and that bank account, and one of the co-owners passes away, and we'll say it's us, so I pass away, the co-owner on my bank account, regardless of what my will says, is going to be now the sole owner of that bank account. And I think that surprises a lot of people. So I'll give you an example that I see quite a bit. When I often have clients who have put one of their children on their bank account as a co-owner for convenience purposes, for the most part. So they wanted that child to be able to access the funds in that account to pay bills or just to assist them if they needed it. So if that individual has a will that leaves everything in equal shares to all of the individual's kids, that joint account is actually not technically part of the individual's estate because it was a joint co-owned asset. So I would say 95% of the time, the child that co-owns that bank account will realize that it was for convenience purposes and will happily give that account to the estate to be administered as part of their parents' will. But I can tell you that on several occasions, that child was unwilling to give that money to the estate to spite his or her siblings. So that's just something to think about. Joint assets are not governed by wills. And we use that for our advantage sometimes too. Sometimes I have clients who will specifically make accounts with co-owners because they want that account to go to that person on their death outside of the will. So just know that any joint assets are not governed by your will. And then the other biggie is any assets that have a beneficiary listed or a transfer on death account. So those would typically be your retirement accounts or life insurance. Some banks with savings and checking accounts, mutual funds, CDs will have beneficiaries listed. I do have clients who will opt to not put beneficiaries on those accounts because they want them as part of the will. And those are specific situations, depending on family situations, I guess. But those beneficiary accounts or transfer on death assets, they are also not part, or they are not subject to a will. So I do see, unfortunately, I have seen sometimes where there's been an individual who was maybe in a relationship, who had a significant other, and had put that person on their life insurance or one of their retirement accounts as a beneficiary. And then after that relationship went bad and a breakup occurred, they forgot that they had listed the individual as a beneficiary. And so down the road, the person dies and we're left giving the ex-significant other the retirement account. So that when you tell one of your account managers and you fill out the form to name a beneficiary, that is binding on the company. The only exception to that would be if you get divorced and it was your spouse. A typical divorce judgment will unwind that beneficiary designation. So that's one parachute that we use sometimes. But just remember that if you've listed beneficiaries on your accounts, it's good to just check on those every once in a while and make sure you have the right people listed, because just doing a will is not going to change who receives those accounts or assets. Okay, so other functions of a will is it allows you to nominate a personal representative, and that's, you would typically know that as an executor, but in Oregon we call it a personal representative. But it allows you to nominate that person and decide who the person will be that is in charge of your estate when you eventually pass away. And that's a huge tool. Because a lot of families or individuals have a lot of people who would be willing or want to step into that role. But in my opinion, and for my personal life, I want to be able to decide who that is, who the person is that's going to be in control, and someone I trust, someone I know who is financially sound and makes good decisions, and who can be a peacemaker. And that's an important nomination that you make in your will. The other thing about having a will is your will waive bond for the personal representative. If you do not have a will, then the person who steps in and serves in that personal representative role has to get a bond in most circumstances. And those can be expensive, but the court will require that. And then the third thing is, and maybe the most important thing, right, is you get to decide the distribution of your assets and how, who and when and why and how much your beneficiaries or devisees will receive from your estate. And that is, we map that out very clearly in a will, and also we plan for every contingency. We try to. So if someone dies, before you, who will then step into their place and receive their gift, etc. Wills can be used also to make or create a testamentary trust, is what we call it. And it's called a testamentary trust because it's created by a last will and testament. You've heard of revocable living trusts, and those are created prior to someone's death by the person and funded during the person's life. But a testamentary trust is created by a will and creates a trust through the will on someone's death. So an example of that would be, and we do this in almost every will, is we will set an age at which an individual will receive their share of an estate. So a typical age would be maybe 18, 21, or 25. And what that does is, in the event you have a grandchild or great-grandchild or someone who ends up receiving a share of your estate, even though they may not be a primary beneficiary, but if they're receiving something by representation, like if their parent had died and they're under a certain age, you can designate the age at which they receive that, that gift. And so in the meantime, typically your personal representative is also named as the trustee of that testamentary trust. And that personal representative holds that asset or that account or whatever the gift is for the benefit of the underage beneficiary. And they use that resource at their discretion to assist that beneficiary, maybe with education or vocational training, or there's some sort of a medical emergency. Those assets can be used to assist the beneficiary. But then when that beneficiary reaches the designated age, whether that's 21, 25, 60, some people really set that age way out, then the trustee turns over to the beneficiary the remaining portion of their gift. And those are used all the time, and they come in really handy when you have individuals who aren't quite ready to receive their share of the estate. We also use them for individuals that you would like to give money to, but are maybe receiving disability benefits. We will leave in your will a testamentary supplemental needs trust so that they can receive part of your estate without being disqualified from their benefits. Or to be perfectly honest, I have many clients who just flat out don't want one of their kids to receive all their share at once. So I do have clients who will say, I want my son, John, to receive $500 a month till it's all gone. So we do that too, if necessary. Wills are easy to maintain. You can always amend your will. I think that might be the next one. You can amend or revoke your will up until the day you die, as long as you have capacity to do that. So if you become incapacitated, you at that point are unable to amend your will or revoke your will. But in the meantime, you can always change your will. And we do that often too. Things change. Your family situations change, your assets change, your goals change. And with a will, it's very simple and easy to change it, to make an amendment, and that's called a codicil. You don't need to remember that, but just know that you can easily change your will, and that's something we do all the time. And we do use trusts for a lot of tax planning situations, but most tax planning strategies can also be accomplished through a will. If you need to make gifts to charity, or you would like to have a special needs trust, or I guess a credit shelter trust for a spouse in order to make sure you're not paying too much in estate taxes, you can do that through a will as well. And so we have to talk about probate, because a lot of people will assume that if they have a proper estate plan that includes a will, that they will not need to go through the probate process. But that is actually false. If you have assets that are subject to your will will go through the probate process in order to get, and your estate will be probated in order to get your assets to the individuals listed in the will. But I just have to say, don't fear probate. I think there must have been some campaign years ago where the word probate became like a terrible swear word, but it's not ideal in some situations. And when you meet with a estate planner, we will go over all of your assets and your family and decide whether maybe you would want a trust instead of a will to avoid probate. But I would say probate isn't the end of the world. And I know what you're all thinking. Easy for you to say, Jessie, because you do it every day, but it is doable. All right. So I thought it might be important to at least go through a little bit of what the probate process looks like, so it's not something foreign for each of you. So my definition of probate is the legal process, which is court supervised, by which property is transferred to the owner's devisees or beneficiaries after the owner's death, and that's in accordance with the owner's will or the rules of intestate succession. So like we talked about before, your probate assets, those assets that are subject to probate, are all those assets in the decedent's name, the deceased person's name alone, at the time of death that did not have that transfer on death, pay on death, or beneficiary designations. So decedent's name alone, so not co-owned, and did not have a beneficiary or a TOD listed on the account. And then those non-probate assets are the opposite, right? Those co-owned assets or assets that had a transfer on death clause or beneficiary designated, those are all going to transfer outside the probate process. And so I would say in most estates, we have a combination of both probate assets and non-probate assets. Well, a typical client who passes away would maybe own their home, and that home would be subject to the probate, but they might also have an Edward Jones account that's got 2 beneficiaries listed on it. And that Edward Jones account is going to be transferred outside of probate to those beneficiaries, while the house is going to go through the probate process and get distributed in accordance with the individual's will. That's a pretty common situation. So when I have a client that comes in indicating that a person has passed away, what we'll typically start with is, did the person have a will? That's the first question I ask. And if so, who is nominated in that will as the personal representative? Because that's really the only person I can deal with as the attorney. That is my client, the personal representative, and they're the only person I can present information to at the outset and deal with in order to get the probate filed and ongoing. And if the person didn't have a will, and that's why we're here today, to talk about why wills are important, then we have to look around and figure out who is going to act as the personal representative. And that can be a really terrible and hard process, because I don't know about your individual families, but I know in my family, I have 3 siblings, and we get along great. But I would fear that at the time one of my parents died, if they didn't have one of us listed, we would probably all want to serve as the personal representative. And then it would be a fight as to who got that opportunity. And then if there isn't a will, the person that serves would typically, like I said before, have to get a bond. And then we have to decide, can that person even be bonded? So it becomes an issue when we don't have a will. And then the next thing we talk about when someone comes in after death is is the value of the decedent's probate assets, because that's going to determine which type of process we file. If you pass away and you have probate assets that include real property, so that's land and your home, of more than $200,000, or personal property more than $75,000, then you have to file a full probate proceeding. But if your real property is less than $200,000 and personal property less than 75, both of those are met, then we file something called a small estate proceeding. And that small estate proceeding, for the most part, they're pretty simple. There's only one thing we file with the court in a small estate, but they're not ideal for every circumstance. So that's something we talk about with our clients at the outset. And I actually have a big packet that I would typically give out at a presentation that kind of goes over probably a lot of boring stuff, but the timelines for our probate in a small estate. But we don't really have time to go over that today, but just know that both the probate process and the small estate process do have some required forms and timelines that you have to meet, but totally doable. All right. I also just want to mention, as a side note, a power of attorney. So a power of attorney is allows you, it's something separate from a will, but it allows you to nominate someone or name someone to act on your behalf in the event you needed their assistance managing finances. That's the main use of a power of attorney. But it also can be used to do things like deal with your utility companies, get medical records for you, pay your taxes. There's a lot of things that a power of attorney can do for you. And I would say, in addition to a will, everyone needs a power of attorney. You would be surprised how many people come into my office. It's weekly, I would say, and they are asking for a power of attorney for someone in their family. And here's an example. I need a power of attorney for my mom because she has Alzheimer's and can't manage her finances anymore. Well, at that point, I cannot ethically have that mom sign a power of attorney because she lacks the capacity to sign it. And when it gets to that point, in order for the daughter or whoever it is that's coming in for that power of attorney to assist their relative or friend, we have to file for a conservatorship through the court. And those can be expensive and time-consuming and kind of an invasion of privacy for the individual. So a power of attorney is a great thing to have at any age to get that signed, because once you lack capacity to sign a power of attorney, you cannot sign one anymore. And then we're stuck doing a conservatorship and unlikely also a guardianship for the person in the court. So another thing that I want to highlight about a power of attorney is it does not take authority away from the principal person, from you. So I'll give you an example. This is at least 15 years ago, right when I started practicing law. I had a lady come in, and her husband was quite elderly, in his 90s, and didn't quite have capacity anymore, but was still operating. He was still driving around, I guess. And he went into the Harley dealership. Remember when we had the Harley dealership here in Albany? And he bought like a $100,000 Harley Davidson. And this lady came in, his wife, and she said, "What can I do about this? You know, he bought this really expensive motorcycle, and they weren't taking it back," which that makes sense to me. And she was just super upset. She said, "I'm his power of attorney, so shouldn't I be able to stop him from doing that?" So actually, no, because the power of attorney doesn't take any authority away from the principal person. It just allows another person to also make financial decisions and manage assets. So I think back on that situation. It's super rare, but where this woman wasn't able to unwind the purchase her husband had made, despite the fact that she had a power of attorney for him. Okay. I also want to highlight the fact that a power of attorney expires on the principal person's death. So if you have a power of attorney and you have someone who is operating under that power of attorney, so they've been paying bills for you and managing some things for you, and then upon your death, they are no longer able to continue using the power of attorney to manage those assets. And at that point is when we would file the will with the court and get your executor or person representative authority to continue getting access to the accounts and finalizing all the financial aspects. So having a power of attorney alone is not a proper estate plan, because they do expire on the principal's death. And so your attorney, in fact, the person named in your power of attorney, does not have any authority after your death to continue managing your assets. All right, so another thing I want to highlight is just the importance of revisiting your estate plan. A lot of things can change in life, and they change really quickly sometimes. So some examples that I see most often are family structures change. So maybe your one of your children gets married. Maybe one of your children gets married to someone you don't like, and that's something that we would need to discuss. Or maybe you start having grandkids and you'd like to leave some of your estate to your grandkids, or set up little trusts for them in your will. Another thing that would change would be your health status, and not only your health status, but maybe the status of the health of one of your beneficiaries. When we have clients who have children or beneficiaries that do become disabled and are receiving disability benefits that are need-based, we have to plan for that, because what we would hate to have happen is for that beneficiary to receive something out of an estate and have that disqualify the beneficiary from their disability benefits and services. So a health status is a big deal, and something that can change. And then another thing really is just your assets change. You maybe would downsize in your home, or maybe the opposite, you buy a vacation home, or add something or obtain more property than you had before. You might change financial advisors, you might change banks. There are things that it's just important to look through every few years to make sure everything that you own is still going to be distributed to the person or persons that you wanted. I forgot at the beginning, did I tell you that my assistant found all these memes? Some of them I took out, but I really like this one. Did you know that your will is only considered legally valid if you leave your glasses resting on top of it? Why is that? Why is every picture of a will has glasses? I don't know. But those are some good examples of what wills look like. So I also wanted to leave you with some cautionary tales about how not to do a will. So over the years, I've had several people bring in what I would call a holographic will, and that's just a handwritten will in Oregon. So in Oregon, for a will to be valid, you need to have the will signed by the testator, the person making it, and it needs to be signed before 2 witnesses, and then those witnesses need to sign a separate affidavit of witnesses that recounts the fact that they saw the testator sign the will and they put their names to it on a certain date, and those witnesses' signatures are notarized. And that is if you just must do that. You must have your will signed by the testator, signed by you, before 2 witnesses, and those witnesses must sign an accompanying affidavit of witnesses. There is in our statute a statute that does say if you have a writing that is purported to be a will of an individual, but it's not properly executed, you can attempt to put forth that writing to the court as part of and present it as a will, but it is very rare that those pass muster, especially if there are individuals who were left out or who might have a claim in the estate, those intestate heirs who would say that's not a valid will. It just isn't worth messing around with an execution of a will. It needs to be executed properly in Oregon, or you face a gigantic uphill battle on whether that will be valid before the court. Another thing another cautionary tale that I would like to tell is there's a lot of online services that will where you can download wills online, and that, in my experience, has been a total disaster for many clients. And the reason is families are complex, issues are complex, and you need to talk to someone who has the ability to fully evaluate your family, your assets, and your goals, and put that in writing in a proper way so that your intent is is realized on your death. So I had an individual not too long ago who had downloaded a will online, and she also had a prior will that was valid and executed validly, but she downloaded this will online and filled it out, didn't execute it properly, but it appeared, and actually I don't think we ever, anyways, long story, but that will went completely contradictory to what her intent was, and became a real issue for the court and for her family because of that online will. So if you're going to do a will, which I think everyone should, as I've said many times today, make sure it's done properly. I wouldn't take any shortcuts. I wouldn't just write it out and you sign it. I would make sure it's got all the correct elements in it, that it's executed properly, and it's kept in a safe place to where your family can find it and utilize it on your death. So I really could probably go on and on and on about the experiences I've had in the last 15 years of good things and crazy things that have happened in estates, but I think what I'm trying to convey, and I hope I have, is that a will isn't hard to do, but when done properly, it is a great tool for you and your family to avoid a lot of heartache, including money that doesn't need to be spent after your death fixing things, and families fighting over little things that could have been handled pretty well through a will. And a will overall isn't an expensive undertaking either. It's something that is, in my opinion, pretty reasonable to do and worth doing. And don't delay, because as I said before, with the power of attorney, a will is the same. You cannot execute a will if you do not have capacity to execute it. So I have a will. I'm 40 years old, and I don't anticipate, I hope I don't die anytime soon, but you just never know, and it's important to me to have things lined out the way I want them to be prior to my death. So everyone needs a will, and you're welcome to ask any questions. There's probably a million of them, but I hope we've been watching the chat, right? Okay.
We have just,
Excellent.
we do have a number of questions, so
Okay.
we'll just go ahead and start. And I did want to mention to everyone that today's talk was presented by Arthur Gallagher Risk Management Services. They're a Samaritan Foundations Pride partner, and we're appreciative of their support. So great job, Jesse. And I'm just trying to get to these in the order that they were shared. The first question was, are joint assets passed to a survivor taxable?
Okay, that's a good question. Meanwhile, I'm trying to get off my, I don't know where hold on a second. I am trying to stop sharing my screen. Okay, there we go. Did I do it?
Nope.
Yes, now I think it's clear.
Okay, great. Okay, so our joint assets taxable. So yes, potentially. I'll give you an example. So if you own, so say Brandy and I going on a joint venture, and we own together a piece of property, and with survivorship. So the deed says Brandy O'Bannon and Jessica Meyer, not as tenants in common, but with right of survivorship. So if I passed away, Brandy would become the sole owner of that asset. Well, for the Oregon Department of Revenue purposes, at the time of my death, I owned 50% of that property, and that 50% is going to be includable in my gross estate that would be subject to the Oregon estate tax at my death. So despite the fact that it transferred automatically to Brandy at my death, I still am going to be, 50% of that is going to be attributable to me. So it's a little bit different when you have a spouse. And if you have a spouse and you have assets that automatically transfer to your spouse because you co-own them together, that is not a taxable event when those assets are transferred to a spouse. But we have to be careful because if you transfer all of your assets automatically to your spouse at your death, that is making your spouse's estate quite large. And so then when your spouse passes away, they only have a $1 million estate tax credit, where there's ways that we want, but you also had one. But if you just allow everything to transfer automatically to your spouse, you don't take advantage of any of your $1 million estate tax credit. So there's ways we get around that in an estate plan.
Okay, thank you. If a power of attorney is signed in one state, is it still enforceable in all states?
Yes, it is, and so are wills.
Okay. Another question from the chat: if there was no estate except for a few $100s in a checking account, does one still have to fill out small estate paperwork?
So there is an affidavit in Oregon. If there's just one bank account, most banks have an affidavit you can fill out, and it's an inheritance affidavit is typically what it's called, where you would tell the bank under oath that you are the rightful owner to those funds, and you take on the liability of receiving those funds from the bank. It has to be a pretty small bank account to do this, but you take on the liability of those funds from the bank. So in the future, if other heirs come forward and say, hold on, like we were also entitled to a portion of those funds, then the bank is held harmless by that person who signed the affidavit, and they could potentially get sued for doing that. So, so no, not in every circumstance. Like a perfect example would be if my husband had a bank account and it was just in his name alone and it had $1,000 in it, and I know for sure that I am definitely the only beneficiary of that account, nobody can make a claim to it, I would feel comfortable going in and filling out that affidavit and taking ownership of those funds.
And then a couple of people are inquiring about, do you have any ballpark about the cost to get a simple will? Somebody was wondering if they had little assets like no stocks, maybe a house, vehicle, personal items, what would be an amount they could budget?
Yeah, well, I can tell you at my firm, we for myself, I charge a flat fee for estate plans. So if it's a single person, my flat fee is $550, and that includes the preparation of a will, the preparation of a power of attorney, and then I usually would go over the medical advance directive form as well, and I know we didn't cover that today. And so the $550 includes the $100 consultation fee that we charge just to have someone come in and talk about their estate. And then when we get all the paperwork together and they come back in to sign, we charge the additional $450. For a married couple, we charge $650. So it's an extra $100. The reason why it's not double is because typically a husband and wife are going to have what we call reciprocal documents or reciprocal wills. They say the same thing, so it's not really double the work for us to complete an estate plan for a married couple.
And then somebody was asking if you could please repeat what you said regarding what makes a will valid in terms of the signatures, just kind of clarifying that language.
Yeah, so in order for a will to be executed properly in Oregon, it needs to be signed by the testator, so by the person making the will, has to be signed by them. And that signature needs to occur before two independent witnesses. So two people outside of your circle, for the most part, that aren't listed in the will, need to watch you sign your will. And then those two witnesses sign a separate affidavit of witnesses, and that affidavit they sign is notarized by a notary. So it takes a small army to execute a will properly, which is another reason why it's just great to do it in an attorney's office, because we've got notaries and witnesses running all over this place. So it's pretty easy to grab two people out of the hall and a notary to watch someone sign a will. So.
Perfect. And another clarifying question, just somebody was wondering, can a husband and wife do a will together, or should they have individual wills?
No, everyone, yeah, wills are individual to the person. There is no such thing as a joint will. There is a joint revocable living trust that you could create, but wills are individual.
And then where can a person get a will properly done? What locations?
My recommendation would be to find an attorney, an estate planning attorney. The preparation of a will is the practice of law. So if it's not an attorney, in order to practice law in Oregon, you have to be licensed by the bar to do that. So you would need to seek advice from a licensed practicing attorney. Lots of great places in our area. I think there's a couple in Albany that are great and I would recommend. There's some in Corvallis. And of course, I prepare wills all the time, so you can call me.
Is the will also where you determine who would be legal guardian for minor children if both parents die?
Yes, it is. Side note on that, funny side note, my husband, you know how they always say like the tailor's kids have the worst clothes, right? And the cobbler's kids have the worst shoes. It was like pulling teeth to get my husband to come in and to sign his will because he and I just couldn't quite decide on whose sister got to be the guardian of the kids, right? So I finally just said, hey, well, if I sign a will and I'm the only one that has a will, they're gonna go to my sister. So anyway, but we agree on where our children should go if we both die. But it was just a funny little side note that my husband for a long time didn't have a will.
There was a question about kind of legal assistance. What if someone is unable to afford or needs kind of financial support to be able to put together a will? Are there local resources for that?
Let's see. I believe that legal aid would possibly be able to assist with that. There's a legal aid office in Albany. And another thing to potentially consider is most attorney's offices, at least my office, we will spread out like a payment for a will for individuals, so that instead of paying everything all at once, we have clients who will just pay a little bit per month till, and we don't charge interest to do that till they're paid in full.
And it sounds like a couple more questions about maybe your practice. Jessica, it says, can you do wills, estate plans for someone in another state? And does your office prepare trusts as well as wills?
Yes, so we typically do not prepare estate planning documents for individuals in other states. The lines between that are kind of fuzzy a little bit because we are allowed to practice law where we're licensed. And I'm licensed in the state of Oregon, so I prepare so that my documents are for individuals in Oregon. So no, I would say most attorneys would not prepare wills for individuals outside the states for which they're licensed to practice law. And then remind me the second question, Brandy.
Well, there was a question about a trust. Excuse me, I'm trying to.
Oh yeah, yes.
Do you prepare trust?
Our office, yeah, we do trusts all the time. Yep. And I have a longer presentation that goes over all the ins and outs of trusts, but didn't have time for that today. But yes, we do trusts as well. And I believe I've tried to cover most of the questions in the chat. There's a couple really specific individual questions that might be better fit for another time, but we have a few more minutes left before we leave at 1 o'clock. Did anybody want to, I'm not seeing any hands raised, I don't believe, but did anybody want to unmute and ask a final question or two before we conclude?
Yeah, I will ask a quick question since nobody else is asking them. a transfer on death deed for your home, primary residence. Can you talk about that, pros and cons?
Yeah, so we, how a transfer on death deed works is, well, basically just how it's named. The individuals that would receive the home on your death don't have any ownership rights until you pass away, but upon death receive the full share or their full ownership of the property. So a downside to a transfer on death deed is, last I checked, there is after death, there's an 18-month window for creditors to come in and potentially make claims on that property. So because of that 18-month window, it's title companies, in my experience, have had an issue with ensuring title to a new owner. So say you received property on with a transfer on death deed, and it was your plan to immediately turn around and get it prepare it for sale and sell it. You could run into problems with that, or at least the title company would probably make you sign some hold harmless paperwork just because of that 18-month creditor period. Where with a probate or a small estate, creditors are cut off 4 months after you file it. So there's just a shorter window of time to cut creditors off. And even within that 4-month window, you're allowed to sell the property. You just can't distribute typically the proceeds from the sale until that creditor period has expired. So I think, in my opinion, a transfer on death deed would work if the person who's receiving the property isn't planning on selling it right away.
Thank you.
Wonderful. And I think there were several questions in the chat, Jessie, about just your contact information, which I believe has been shared already in the chat. And then also just to reassure everyone that if you did register for this presentation, you will receive an email with the survey. We'd love for you to complete that survey. And then we do provide a recording of this presentation. So many of you wanted to share that with friends and family. So know that you'll receive that in a couple days. So we are getting towards the end of our time, so I think we're going to go ahead and end our time today, but I wanted to thank Jessica Meyer for her time and excellent information. I wanted to thank all of you for joining us today for our Samaritan Foundations talk. And I did want to highlight that we have other talks coming up this summer. So July 23rd at noon, there'll be a presentation on Samaritan's health equity initiatives. And August 20th at noon, there'll be a program on our total joint program. So you'll receive some invitations, and we hope you join us for further presentations. But thank you again, Jessica. We really appreciate it.
Thank you.
Have a wonderful afternoon, everyone.